So we are now at the stage of having a pretrial motion, which is just supposed to be hearing the facts and determining if there's enough to move forward with setting a trial. Now, at the time, we had 2 claims against the city and parish, and we were requesting to add a 3rd claim to our case. And in this pretrial, the parish and the city were requesting a dismissal based on prescription, which is the amount of time that you have to file a case against somebody. Now, our first 2 claims, I'm not even going to really go into that, because if you can look up the case and read those details regarding it. But what happened at this pretrial is that I had to take the stand under oath. Jason had to take the stand under oath. The city and the parish requested Kevin Chury from the Slidell Independent to take the stand under oath, because at the time he had came to our property one time to do an interview, and he wrote down timelines in his news article about us that were not factual. Let me add about his testimony. I mean, this is under oath. He's advised he doesn't take word for word comments. He doesn't write them down. He doesn't keep notes. He gets the gist of what somebody says and then writes his articles from there. Not a factual journalist, in my opinion. I want to also remind people, yes, did I email the city? Yes. Did I? Because again, we were asking for months, come help us. I think the culverts that you just installed a few years ago are the problem. I don't know what to do. I found these mitigation studies that y'all ordered and are having a committee for. I found these studies which advise about the erosion of the canal. I did email them because I was begging for help. I was afraid of losing my house. I lost it anyway. Now, I want to explain that part of our counter argument to this prescription time period was, I don't know. I am not an expert. I don't have anything to do with construction of culverts. I don't have anything to do with the drainage. I don't know anything about water flow. Do I, to this day, do Jason and I know if it's the culvert that is causing that? Absolutely not. No, no, we don't know. Could it be all the additional developments that they've done that have diverted more water flow to go down the W14? Maybe. I don't know. Could it be a lot of other factors? Possibly. I don't know. But in the end, Cody decided that we had knowledge to know that when the culvert's construction ended in 2011, which gave us a 1-year and a 2-year timeline to file this suit, we had enough knowledge to know then that this was going to damage our property. I had enough knowledge to know that water flow was going to go through and erode 25 feet of this easement on this drainage canal into like another 15 feet that was on the side of the house. You know, I'm an expert. I know. I'd like to remind everybody too that this canal was built in like 1960 or 50. My house was built in 1970, and to the point until we saw stuff, we didn't have any problems. Moving on, that day of pretrial, the way it was left was that we were going to be coming back another month or so later to do a ruling regarding the 3rd claim. And again, I'm not a lawyer. I'm sure somebody else can explain this to you better, and I could be not interpreting this correctly. So please bear with me. This is how I understand the actions that have taken place in my lawsuit. So it was still supposed to be an open case. In the meantime, between the time period we had our pretrial motion regarding the first 2 claims to our case, and we never even got to the date of having the pretrial for our 3rd claim, Martin Cody made his decision on the outcome regarding those 2 claims, saying that, you know, we had enough knowledge to know that was going to happen. I still don't quite understand this a lot, because I didn't think you could file a lawsuit until you had damages. Anyway, in his write-up, he wrote up dismissing our entire case instead of dismissing those 2 claims. The accident was caught like 31 days, 32 days, some crazy number, like, to me, a relatively short time frame considering how long it took us to get to court. But the error was caught, I think, by his clerk, his legal clerk, or somebody like that. Attorneys were brought into a behind the chambers meeting, and the mistake was notified to everybody. And this is where the conundrum of this case has gone sour. Instead of Martin Cody, I don't even know what they do legally when you make a mistake like that, but instead of doing any recourse for it, he left it up to our 3 parties to work this out. They don't want to help me up to this point. What are they going to try and work out with me? Can you make that make sense?